Hi everybody, welcome to the fifth video for Legal Studies 34. In today's video, we're going to be covering the pre-trial procedures, court hierarchy, and the key personnel. To start off with, the first type of pre-trial procedure that you need to be familiar with is pleadings. Pleadings are a series of documents which are filed and exchanged between the parties and with the court. The main purpose is to outline the claims and the defence and also set limits to the dispute. So once the statement of claim is issued by the plaintiff, that outlines what the plaintiff is arguing, what their claims are against the defendant, and what they are seeking. The defendant will respond through a defence, which outlines how they are going to respond to the plaintiff's claims. Once those documents are filed with the court, they cannot change the claims and defences. So it sets a limit to the dispute for both parties. Pleadings uphold fairness as they ensure that the parties are aware of the claims against them and can prepare accordingly. Pleadings uphold equality as both parties are required to state the main facts of their case and claims. Pleadings uphold access as it prevents unnecessary delays by setting limits to the dispute, because the defence can't then think of another defence and raise that later on, or the plaintiff cannot change how much money they're seeking later on. It also encourages access by facilitating out-of-court settlement, because if the defence sees all the things that the plaintiff is arguing and how much they're seeking, they may realise that their case is not very strong to defend those claims and will offer an out-of-court settlement in order to avoid the cost of trial. However, pleadings reduce fairness as they add to the delay, and remember that delays can undermine the accuracy of the evidence and the accuracy of witness testimonies. Furthermore, pleadings reduce access and equality as it's very expensive to file each document with the court, and so they increase the costs involved. The next pre-trial procedure that you need to be familiar of is discovery of documents. So discovery of documents is where parties will exchange all relevant documents to trial. This includes contracts, emails, receipts, medical records. This upholds fairness because it eliminates trial by ambush and surprise. The parties are familiar with what the main pieces of evidence and documents that their opponent is going to be presenting in court, and they can respond and prepare accordingly. Discovery upholds equality because both parties have the responsibility and obligation to provide documents. And it upholds access by once again encouraging out-of-court settlement, because if the defence sees that the plaintiff has a very strong document which is damaging for the defence, then it may encourage the defendant to provide out-of-court settlement in order to avoid trial. However, as we mentioned before, this may reduce fairness because discovery of documents is a very lengthy process and it adds to the delay significantly, which can undermine the accuracy of evidence, which may mean that the ultimate decision and the damages awarded may not reflect the severity of the case. And finally, discovery may reduce equality and access because, once again, there are costs associated with filing documents with the court. The final pre-trial procedure that you need to be familiar with is exchange of evidence. So this is where parties exchange the details of the evidence that they will present at trial, not the documents that we mentioned before, but instead the actual witnesses that they will be presenting in court. There are two different types of evidence. The first is lay evidence. So this is ordinary people, usually witnesses, who will give evidence about the occurrence of events. The other type is expert evidence, which is where an individual with expertise in a particular relevant area will give their independent professional opinion, usually in order to strengthen one of the parties' cases. So either a written outline of what each witness is going to outline in court will be provided to the opponent, or a video record will also be provided. This upholds fairness by reducing the element of surprise and trial by ambush once again, and it allows parties to prepare accordingly. It also upholds equality because both parties have the obligation to disclose witnesses and evidence, and both then have the opportunity to rebut their opponent's evidence. So if the defence sees that the plaintiff has obtained a medical profession through expert evidence, they can obtain a medical expert who has the opposing view to kind of counterbalance that, the credibility of that witness. And finally, exchange of evidence encourages out-of-court settlement, therefore reducing costs and time involved, as the defence may say that the plaintiff has a very, very strong case and therefore will be encouraged to provide them with an offer prior to trial. And as we said before, this is again a lengthy process, and the delays undermine fairness, as it may undermine the credibility of evidence and testimonies. Now we move on to the court hierarchy. The court hierarchy is the same, with the High Court at the top, followed by the Supreme Court Court of Appeal, Supreme Court Trial Division, County Court, and finally the Magistrates Court. Starting with the Magistrates Court has an original jurisdiction of claims up to $100,000. So civil law is slightly different to the criminal law hierarchy in the sense that different types of disputes aren't allocated to different courts. So it's not like in criminal where the Magistrates Court only hears summary offences, which include traffic offences, driving offences, that kind of thing. This is based on the amount of money that the plaintiff is seeking, because there can be all different types of claims and cases which are for different areas of law but seeking similar amounts of money. So it's easier to allocate it based on that, because you could have breach of contract for $10,000 or breach of contract for $100 million. So the Magistrates Court hears claims up to $100,000. The County and Supreme Court have unlimited original jurisdiction. So parties can choose whether they want to have their claim heard in the County or Supreme Court for the most part. This means that usually cases which are seeking less amount of money will be heard in the County Court, because parties will choose to have less delays and lower court filing fees. So it usually happens that parties seeking, above $100,000 but to a lesser amount cases will be heard in the County Court, whereas cases seeking millions of dollars and have very complex legal issues will be heard in the Supreme Court Trial Division. The Supreme Court Trial Division also hears appeals on a point of law from VCAT when it is heard by a member or senior member, and also appeals from the Magistrates Court on a point of law. The Supreme Court Court of Appeal has no original jurisdiction. However, it hears appeals on question of law, question of fact, and damages from the Supreme Court Trial Division and the County Court, and on a point of law from VCAT when the decision is made by a president or vice president. Now we're going to go back through the reasons for the court hierarchy. These are the same as the ones we learned for criminal. However, we need to tailor them slightly to the civil law. So again, without the court hierarchy, there would be no system to outline what judge has the authority to review and change a decision of another judge. Appeals operates in the civil court hierarchy just the same as criminal. And so more experienced judges in higher courts can review decisions and correct the mistakes of lower court judges. Similarly, the doctrine of precedent operates at civil level as civil law as well. And so without the court hierarchy, there would be no system to outline what judge is bound by another judge's decisions. And so lower court judges are bound by higher court judges, but higher court judges are only persuaded by lower court decisions. Next, administrative convenience. Again, cases are based and allocated based on the amount of damages that are being sought and consequently the complexity of the legal issues. And so that means that the resources can be allocated more appropriately to the types of cases the courts hear. And also that the fees and delays are proportionate to the complexity of legal issues and the amount of money being sought. So the delays and court filing fees for the Magistrates Court are a lot less than in the County and Supreme Court. And finally, judges have specialisation over specific areas of law because they hear similar types of cases on a daily basis. And that allows for judges to make more efficient decisions and make more appropriate decisions about the remedies being handed down. I think that specialisation is slightly easier to explain for criminal, just because for criminal law, remember, judges in the Supreme Court hear murder cases on a daily basis, whereas magistrate court judges hear traffic offences on a daily basis. But because the civil law court hierarchy is allocated based on money, it's a bit harder to argue specialisation, but it is still relevant. Now we move on to the key personnel. The jury is 6 members of the community randomly selected off the electoral roll who cannot have any connection to the parties. So they must remain objective and impartial throughout the entire trial. For civil law, juries are only used when either party requests it, and the jury, the party who requests the jury must pay for the jury. The jury spreads the burden of decision making as it's shared among 6 people rather than just one judge, and that limits any bias in the decision. For civil, when there's a jury present, the jury not only determines the verdict, whether the plaintiff is successful and whether the defendant is liable or not, but also the amount of damages awarded to the plaintiff and how much money the plaintiff will receive in order to compensate them for the loss that they've suffered. However, this is not the case for defamation. The judge will determine the amount of damages sought for defamation. That's just an extra point. The jury has to listen to all evidence presented and follow the judge's directions. However, similar to criminal law, they don't give reasons for their decision, so it's unclear whether they have been influenced by the legal arguments or potentially any inherent biases. Further, the jury is not experienced in the law and they may not understand the evidence and the legal arguments. And juries may have inherent biases due to personal ideas or the media. Moving on to the judge. The judge is an impartial arbiter who ensures that court processes are carried out and that the parties' rights are upheld through administering things such as the rules of evidence and procedure. The judge directs the jury and ensures that the jury is familiar with court processes and any legal jargon used in trial. The judge also rules on the admissibility of evidence and can use case management powers to streamline the case, which we'll be covering in the next video. The judge cannot overly interfere in the dispute despite their legal expertise and experience in the law. And so whilst they can assist self-represented parties to some extent, if they are considered to have overly intervened, that's cause for a mistrial. When there is no jury, the judge determines the verdict and the damages. However, when there is a jury, the judge has a very limited role for civil law because the jury is responsible for both the decision and the damages. The judge will provide written reasons for their decision in cases where there is no jury, and the judge also has the responsibility of determining an adverse cost order, so determining whether the unsuccessful party should pay the successful party's legal costs and how much the unsuccessful party should pay of it. Now moving on to the parties. So the parties are the plaintiff and the defendants. Similar to criminal law, they have party control and they can choose what evidence and legal arguments to present. The plaintiff must also fulfill the burden standard of proof and prove that the defendant is liable. Parties also have to adhere to the 10 overarching obligations, which are outlined in the Civil Procedure Act, which include to act honestly, not misleading the court, to reduce delays as much as possible, ensuring costs are reasonable and proportionate, and to disclose all relevant court documents. Finally, legal practitioners. Legal practitioners have to represent their client in the best light, and they have to assist the court at reaching their truth. The legal practitioner's primary duty is to the court, and so they have to ensure that they do not mislead the court, even though they have to represent their client in their best way. The defense has to defend the defendant regardless of their personal beliefs and opinions. Remember, though, that legal practitioners do increase costs significantly, and it may disadvantage the defendant if they cannot afford high-quality legal representation. Remember as well, there are 2 different types of lawyers used: the solicitors who prepare the legal documents and the barristers who advocate for the party in court and present the arguments to the judge and jury by presenting opening and closing statements and cross-examining witnesses. Legal practitioners are also subject to the 10 overarching obligations, as are parties. So that brings us to the end of lesson 5. In the next video, we'll be finishing off area study 2 by going over case management, ADR, remedies, and reforms. Thanks.